Your Honor, is there any way I can bring something to your attention without interrupting you? And I'm very sorry. My name is not Galen, and they got me under my brother's name. So I'm in here under his name. So how do I get out?
Welcome back to the channel, where the truth is stranger than fiction. Today, we are diving into a courtroom double feature that starts with a habitual offender begging for his absolute last chance at freedom, only for the judge to pull up a $100,000 receipt of his past failures. But stick around, because right after that, a routine arraignment takes a mind-bending turn when a defendant claims the police locked up the completely wrong person under a sibling's name. Is it a desperate lie or a massive systemic failure? Let's roll the tape and find out.
No, not from the state.
All right, then you may proceed, Mr. Lewis.
Judge, as far as this situation, Mr. Dinkins, with Mr. Dinkins, we know it's a big ask. He is asking that the court consider keeping him on probation, maybe amending his conditions.
Well, first of all, I can't continue him
Okay.
because his probation expired in 2024. So the only option would be to revoke him, sentence him to time on a straight probation. That's the only option other than regular time.
Well, let me rephrase that, Judge.
Okay.
We'll understand that, okay, even if he is the conviction, he does take the conviction and he goes to a straight probation. What Mr. Dinkins is asking for is the opportunity to get the help through probation that's available to him. He know he is messed up, and there's times that he hasn't in the past taken taking those opportunities that was available to him. He's more than willing to try to do that for us, the anger management and the things of that nature. He's trying to better himself. He's a lot older now, to where he can kind of really realize where he is in life and what he wants to do with himself going forward. He knows that probation can help him. He understands that, if given that opportunity, it would probably be only one opportunity, and it'd be a zero tolerance type situation. And that's what he's asking for, Judge.
All right. Thank you, Mr. Lewis. Mr. Smith?
Judge, I would disagree. I think revocation, he had a chance at probation. He absconded. He did nothing. We have no idea what he had been doing for that time. And so I feel like PDC time is appropriate in this case. He was given a chance by his own choices. He believed that.
So, Mr. Dinkin, Mr. Smith went a little light on the chances that you've been given. Because when you were placed on probation back in 2019.
Notice how the judge immediately shuts down the defense's narrative that the defendant is older and wiser now. She points out a crucial fact. Back in 2019, he was already 39 years old. This wasn't a reckless kid making rookie mistakes. This was a grown man who knew exactly what he was doing. In legal terms, when a defense attorney asks for a zero-tolerance probation after their client has already absconded, it is usually a last-ditch effort to keep them out of prison. But as the prosecutor rightly pointed out, he already had his chance and ran. What do you think? Is 39 too old to use the growing up excuse?
Previously been given that opportunity to go through the ATAR program, you had made no effort to enroll in it. So number one, there aren't any other things to do. You will have had everything we have to offer at that point. If I send you to safety, we will have spent probably over $100,000 on you individually for this help. Do you understand the opportunity? And I don't want you to go take this bed from someone else and not take advantage of it, because that's what you've done so far. I got a memo, I'm sure, that said to send you to ISF, which I did. And you went through both tracks of ISF, the cognitive and the substance abuse track. And the end of 2022, you got out 2023. You started testing positive for alcohol within a month of getting out of ISF. And you were then referred to the DROP program to help you, even though you had just gotten out of ISF, and you never showed up, and you've been gone ever since. So I don't know what other options or things we could do for you. You've been given every opportunity to have whatever treatment you need to be able to stay out, take care of your family, as you say. But that's not what you've been doing. So, I mean, you've been gone since 2023. Anyway, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon to a family member. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon.
And just like that, the hammer falls. 8 years in a Texas state prison for aggravated assault with a deadly weapon. The judge laid it out beautifully. The state spent over $100,000 trying to rehabilitate him through specialized substance abuse and cognitive programs, and he threw it all away by disappearing for months. There are simply no cards left to play when you exhaust the court's patience. But don't blink, because the mood in this courtroom is about to shift drastically. The next defendant up is about to drop a bombshell that leaves everyone completely baffled. Watch this.
Okay.
So how about we start with the things I have to do, which is first tell you what you're here for. You're
Yes,
here
ma'am.
on 2 KPSs for case number 2025 CF 9001 and the 2 charges associated with that, and case number 2025 CF 9000.
I don't know what that is.
2 charges associated with that. Would you like for me to appoint the public defender to represent you in these cases?
I guess so, but I don't understand how I'm in here under his name.
Well, we're not here on a trial or an evidentiary hearing for me to...
I'm Galena, though. I'm not Galen. I'm Galena.
Talk about a legal nightmare. The defendant is insisting that she isn't even the person named on the docket, claiming she was booked under her brother's name instead. Now, to the average viewer, it looks like the judge is being totally dismissive, but legally, the judge's hands are tied in initial hearing. She doesn't have the arresting officers there to verify identity, so she has to proceed based on the paperwork provided by the jail. But you can feel the frustration radiating through the screen. Do you think this is a genuine clerical error or a classic stalling tactic?
If what you're saying is true or not. Represented by the public defender's office on one count, on one case. Ma'am?
Okay, yes.
We're going to answer my questions, okay?
Yes, ma'am.
Charge.
I don't have any burglary.
It just keeps getting more confusing. Now she claims her ID lists multiple other names like Jay and Janine, and she's facing 4 separate charges, including burglary, which she flatly denies. When a defendant continuously interrupts a judge during an arraignment, it never ends well. The judge is trying to establish basic rights and set a bond so the woman can actually get a lawyer to fix this identity crisis. The defendant's panic is completely overtaking the room. Let's see how the judge wraps up this chaotic situation before the tension boils over completely. What a wild sequence of events. We witnessed 2 vastly different sides of the justice system today. First, Mr. Dinkins' case wrapped up with a firm 8-year prison sentence, proving that the court's financial and structural patience does eventually run out. Second, we watched absolute chaos unfold as Galena protested her very identity, leaving her with a $10,000 bond and a public defender assigned to untangle the bureaucratic mess. Arraignments are meant for administrative processing, not proving innocence, which is why the judge had to move on.